Good morning, everyone. I believe we are now live. Thank you for joining us this morning. My name is Dean Lennon. I am one of the partners here at MEEB. I've been here since 2009, and with me is Will Thompson.
Morning, Dean. How are you? I'm just debating. I'm seeing people kind of clicking in here, so I'm just going to give it a couple of minutes. The numbers going up, so
Very good. Yeah, you can see things that I cannot, so that makes sense.
I do see things. All right, it looks like we steadied off there. For those of you who missed Dean's introduction, this is Dean Lennon, his partner here at MEEB, as well as I am a partner here at MEEB. I've been at MEEB now for close to 15 years. I started at MEEB back in 2008, back in the midst of the housing crisis. For those of you who remember, were in the industry during the housing crisis, you remember it was an incredibly precarious time for condominium associations. There was a lot of financial uncertainty, a lot of unknowns as to where budgets would be filled as condominium unit owners weren't paying their condo fees. If you weren't in the industry, it wasn't uncommon at that time for medium to large condo associations that 10, 15, 20 unit owners wouldn't be paying their condo fees at one time. You can imagine today if 10, 15, 20 unit owners weren't paying, how that would mess with the association's ability to operate. Fortunately, we were in Massachusetts, and Massachusetts has a law that's very favorable to condo associations, and it enables them to collect common expenses when unit owners aren't. So that really, unlike other states, many states around the country don't have similar laws, and when that many unit owners aren't paying their condo fees, it just they can't afford to operate as a condo association anymore. It's a terrible situation. So in Mass, we do have that law, so we won't dwell on the states that don't. In Mass, the law that protects associations is called Mass General Law, Chapter 183A, Section 6C. It's up there on your screen. I'm not going to bore you with reading through the statute, but I will tell you that what makes it great is that it's a law that prioritizes the association's lien, which is why it's more commonly known as the Superlien law in Mass. And what is essentially it does is it prioritizes some of the association's liens over other existing liens. Primarily, or most importantly, it prioritizes the association's lien over the first mortgage's lien. And that's really important because that forces a mortgage holder, the bank, to make a decision. They either have to decide to step up and pay the common expenses, or they have to let the association foreclose on the unit. And if the association forecloses on the unit, it potentially wipes out their first mortgage. So it's a real tough decision for banks to make. And ultimately, in most cases, they would step up and pay certain common expenses to prevent the association from foreclosing. But if they don't, then the association can foreclose and recover certain common expenses. So it really puts the association in a good position. Now, it isn't without limitation. It is super, but it does have limitations. And there's also, it's not automatic. There's certain things that the association has to do in order to perfect that super lien. So today, this morning, Dean and I are going to go through what some of those things that the association has to do in order to perfect the lien, and we'll also get into some of the limitations. So with that said, Dean's going to kind of run down the process for getting a lien in place.
And hopefully I'm not going to cough throughout this thing. I'm going to try to save my coughs for Will's slides, but we'll see what happens. But what Will talked about just then, the critical thing here is not only do you have the 6-month priority lien in the statute, but it's the ability to foreclose on that lien. The two things together, which makes the Massachusetts super lien so powerful. I do maybe half of my practice in New Hampshire, where there's a 6-month priority lien, but no ability to foreclose. So if the lender doesn't pay it, you're stuck. if you have an owner who's vanished and a lender who just doesn't feel like paying, well, there's nothing you can do about that. Whereas here in Massachusetts, you can foreclose and recoup what's owed on behalf of your client. So it puts the bank to the test, and you have all the leverage you need to get paid in most circumstances. So let's talk about the nuts and bolts of that process. And this is all laid out in section 6C. That was on our prior slide. So it all starts with sending a statutory notice to the unit owner as well as to the lender. Typically, we want to send a notice. Well, let me step back. In an ideal circumstance, the management company or board is going to send a notice to the unit owner, maybe when they're a month behind, maybe 45 days behind. Hey, Mr. Smith, you passed due for January. We'd like you to send in that payment. Once you get to a second month delinquent, maybe you send one more notice. Mr. Smith, we see you haven't paid for January and February. If you don't pay by the 15th, we're going to send this to counsel. And when we do that, you're going to be responsible for counsel's legal fees. So in an ideal world, Will or I are getting this file when the owner is about 3 months in arrears, and we're going to send a notice to that owner. Now it's up to us to figure out who the owner is. Sometimes you have it as John Smith, but in reality, it's John Smith, trustee of the Smith Realty Trust, or it's John and Susie Smith. The point is, you can rely on us to search the registry records online, figure out who the lawful owner is, and send that owner a letter. If that fails, in the next month 4, ideally, we're going to send notices to the first mortgage holder. And again, excuse me, the best thing about COVID was no one got sick, and now that COVID is mostly over, now I'm sick and I can't get well, so I apologize for all the coughing. So we're going to go to the registry. We have a title person here who is a whiz at this sort of thing, and Will and I can do it ourselves as well. Find out who that first mortgage holder is and send them 2 notices. One is the 60-day notice saying the unit owner is 60 days or more in arrears. And the second notice is a 30-day notice saying that in 30 days, we may have to file suit to enforce our lien on the unit. Now, the final step in the process, after you've sent your 2 statutorily mandated notices, is to file suit in a court wherever the property exists. If your unit was in Braintree, would file suit either in Quincy District Court or in Norfolk Superior Court, because those courts cover Braintree, and then record a copy of that complaint with the Registry of Deeds. And again, this is stuff, everything I'm talking about is things are things that we handle for our clients. This is not things you have to worry about doing for yourself, but we're trying to make you understand the process we go through to secure a lien. And the recording of the complaint within 30 days of filing suit is what creates the super lien. And Will, you want to just take this slide just so I can get a lozenge?
Sure. And I will say, to Dean's point, again, this is it's a bit dry. And actually hearing Dean and looking at it, it is dry. It's a lot more exciting in practice, I can tell you, getting to do this stuff. But, just to reiterate, it is so important that the association get those first notices out. It's nothing worse than when we send out notices and the owner has no idea, and then they've already racked up some legal fees. So to the extent you can do that, that's great. So proceeding to judgment and obtaining an order to foreclose. So at this point, all right, one thing I'll say before we get to that is the lien for unpaid common expenses is automatic. The day an assessment is charged to the unit, it's a lien against the unit. So on November 1st, every unit owner is going to have a lien on their unit for the November condo fee until it's paid. And what we're talking about is how you perfect that lien in order to prioritize it as far as the super lien is concerned. Or even if you weren't even if there was no other liens on there and you were just going forward to enforce the lien, this is the process you would take. So now Dean walked us through the part where we've got a complaint on record. And so we're official now. The whole world can see that we're on record with this lien. So the legal process now is you have to give you serve the unit owner with the complaint, and then you have to give them a certain period of time to file an answer. If they do not file an answer, we file what's called a motion for default judgment. If they do file an answer, it's called a motion for summary judgment. And these two motions, at least in the condominium context, are extremely similar. And the reason being is not only is the statute very favorable towards condominium associations, but the law is also, the case law out there is incredibly favorable to condominium associations. And pursuant to case law, a unit owner has to pay their common expenses. There's absolutely no defense. The fact that the place is falling apart, the fact that they don't like the management company, really have no bearing. And in fact, the case law says that absent a prior determination of illegality, they have to pay it under protest and file a separate action. So when we go in on this motion for default judgment or summary judgment, they're very similar. And in most cases, a judge is going to rule in our favor.
But Will, the paint on my front door is chipped and it needs painting. Surely that excuses my non-payment of fees. Surely.
Well, I understand where you're coming from, Mr. Lennon. And we have kind of neglected that door for the past, few years. But it doesn't help that you keep kicking it in with your dog that you're not supposed to have. But in any case, the paint on your door is no excuse. And again, unit owners might have legitimate gripes. A lot of times there's only so much money to go around a condominium, and they have to prioritize what gets done. And what one unit owner might think is important, another unit owner might not think it's important. So you always run that risk that somebody's going to be disgruntled about what's being done. But as far as we care about in a lien enforcement context, doesn't matter. And that's typically how the courts see it as well, with a few exceptions. And we'll get into that later. So then there would be a hearing. And again, most 9 out of 10, there's no issue, and we get our judgment. Once we have the judgment, it's a judgment in order of sale, and we can begin the foreclosure process. And at that point, we would schedule a foreclosure sale, and there's certain I won't get into the legal things that we have to do, but again, there's certain procedures we need to follow to make sure that the sale is done properly. But then once that occurs and we've done those steps, we can go ahead and foreclose on the property. Dean, you're muted.
Thank you. I have to press my cough button. So once we, obtain a judgment and schedule an auction, the owner is going to get, and the bank, a final notice, at least one, saying, look, it's go time. We are foreclosing approximately 30 days from now, unless you pay this lien in full. And, we're foreclosing, I've never calculated it, but it's probably less than 1% of cases, maybe even half of 1%. It's very rare, but it does happen. I probably do 5 to 7 a year, something like that. Usually the bank, there's no bank, the owner's vanished, things like that. But occasionally lenders just drop the ball and they don't respond, and we foreclose. But there is, many opportunities for the unit owner and the lender to do something about this before we actually conduct an auction.
Yeah, and I would just add to that, Dean, at least in my experience, it is pretty rare that it actually goes all the way to foreclosure sale. Even back in 2008 and 9 and 10, when a lot of people had just walked away from their properties and the banks weren't getting paid either, not a lot go to foreclosure, at least, through a condo lien foreclosure. So it's typically, as Dean just pointed out, that the owner's just disappeared or is deceased or something along those lines.
And one other sort of practical thing that came to my mind, a lot of clients, they get frustrated when banks don't pay right away after we send our first notice. A lot of banks that we deal with have policies. And one policy is that they won't pay until there's actually a recorded complaint. Even though if they pay, in the 3rd month or 4th month when they're getting a letter from us, maybe, $1,000 is owed. But by the time we file suit, it's, maybe $2,500 or $3,000. Regardless of the fact that that makes no sense, a lot of lenders just won't pay until we file suit. So as hard as we work on these and as quickly as we sort of process them, there's only so much we can do to actually get a payment for our clients, because if a bank has an internal policy, we're stuck with that. Years ago, TD Bank had this insane policy that we basically needed to get a judgment before they would issue a payment. So you're talking about a 9-month process, from the start of the first delinquency all the way to judgment. That's a long process. But nevertheless, that's what they wanted to do. So we're just going to talk. I think Will's going to talk about this on the next slide, but this is sort of a generic account ledger. What you'll see on it are some really old fees that are owed, this balance forward, monthly fees, late fees, a special assessment, which we'll get into the no-nos of special assessments, and a grand total. So you have this, Julie, our office manager, sent you these slides this morning. If you want to refer to it, just talking about how we figure out what the priority lien is when we're dealing with banks and their attorneys to get our clients paid.
Dean, I'll go through that. Before I do, if you could go back to that ledger, I just want to point out a couple things, but we also had a question that came in while you were speaking related to a foreclosure sale, and I thought just want to take it now before we get too far removed from it. It says, is there an option of fast forwarding to foreclosure rather than continuously sending notices until the financial institution finally pays the outstanding monies? So just, and then there's a follow-up. I asked, I have a property that has a significant amount of fees, 27K outstanding, that includes legal fees and late fees. Unfortunately, there really isn't a way to fast forward right to foreclosure. The statute lays out very kind of specifically the steps that need to be followed in order to get the lien in place and to get the order of sale. So, again, I understand not knowing what that 27,000 is comprised of. It's uncertain whether or not if there's priority issues there, but in that general question of is there a way to streamline it, there really isn't. You can tweak it. You don't necessarily have to wait till a unit's 6 months in arrears to file suit. Like, you can shave some time off. If you file in district court, you can probably push it through quicker than going through superior court. So there are some ways that we can expedite the process, but overall you have to follow that same pattern. And one last question, then I'll get back to that, just again on the foreclosure. What if unit owner who hasn't paid condo fees owns his unit outright, so there's no mortgage? How can you foreclose? That's a great question. We spent a lot of time in this presentation talking about the priority lien and the banks and other liens. But what about an owner that doesn't have a mortgage? You're in a great position if there's no mortgage on the property. The only thing you have to worry about are taxes, but those typically aren't too bothersome. We can kind of get around that. But you go through the same process. Simply put, you send the same notices and you get your judgment in order and you schedule a foreclosure sale. All right, back to the priority lien amount. Dean, would you mind going back to the ledger? So this is a ledger that's got a little bit of everything on it. All right, and this is always if I receive a ledger like this, from a management company or a condo association, it can be problematic because right off the bat, there's a lot of things on here that won't fall under the priority lien.
And by the way, it's 2017 in our world today. It's not.
Because we've given this seminar, nobody gives us ledgers like this anymore. We had to go all the way back to 2017 to give you an example. But ideally what we would see in a ledger that you would send over would start in August of 2022. So you'd have the August condo fee, the late fee, the September late. That's where it would start. And when you send this ledger over to us, the association would have already sent out a notice or two to the owner, letting them know this was happening. So in a perfect world, start there at August, September, October. That's what we should be receiving. That being said, it's not perfect. And a lot of times we do receive something like this. So, and you can see there's this beginning balance. Now, one thing I'll tell management companies and associations, a lot of times we get this beginning balance when there's a shift from one management company to another, and they just get this beginning balance. To the extent you can break that balance down, it's really important. I know it's not always easy, but inevitably, if we end up before a judge, they don't like to see just a beginning balance that we can't break down. So to the extent that can be broken down, it should be. Okay. Now, so we'll talk about, I guess we can go to the next slide and see what on this is considered priority, what isn't priority. So what is priority now is going to be 6 months of condominium fees. All right. So May through October. So that's assuming that, maybe we didn't get it in October, maybe we got it in September or August and notices were sent out. Then we're going to be able to file suit in October, and we're going to be able to prioritize $1,200 in condo fees. We're also going to be able to prioritize all the legal fees and any court costs to date. So 1,295. So 2,495. So Dean, if we can just go back real quick. So out of that balance, only the 2,600 and 495 is considered priority. The rest is behind the first mortgage. If there's no mortgage, doesn't matter. But if there's a mortgage, there's going to be a challenge to get those other amounts.
And what we want to hopefully leave you with here today is that this was an avoidable situation. The management company in this situation, or the board, they dropped the ball. We should not have gotten this file in September or October, whenever it came over. It should have been, sometime last year in this example.
And there are times when, boards try to do the right thing. And, it's somebody who'd never been delinquent before and hit hard times, and who knows, and the board tries to be helpful, and it gets away from them. And then that's the point that they have to do something about it. They're jeopardizing some of the association's money. So you got to be careful of that. So here's the non-priority amounts, that beginning balance we talked about. Those condo fees that fell before the priority lien period, any late fees, any special assessment, and any fines are not going to be recoverable. Dean, do you want to talk about that special assessment and what could maybe be done different to collect that in the future?
Absolutely, yes. So if you went and looked at section 6C that we started off with, it explicitly says the priority lien does not include late fees, interest, fines, or special assessments. The idea of the priority lien, and by the way, we should have noted this at the top too. The priority lien was created through the efforts of the founding partners of this firm, Stephen Marcus, Richard Brooks, Seth Emmer, and Doug Arrico. They led the charge to get this created in 1993. So we sort of consider it our firm's baby, so to speak. But anyway, the idea was, monthly fees are what you need to survive. You have your budget. It's what you need to pay for insurance, to pay for maintenance, and so forth. So it's critical that nut get paid. So the purpose of the priority lien was to make the budgeted fees the most important aspect of what's collectible. So special assessments, by their nature, are outside of a budget. They're for the unexpected. A tree falls on the roof, and you have to, that's not in the budget because you did not know a tree was going to fall. So now all of a sudden you need to raise $5,000, and 10 unit owners pay $500 each. You're not going to get that paid as part of the priority lien due to the wording of the statute. So there's sort of a workaround that I'll give credit to Richard Brooks for creating, and that's the supplemental assessment. So what you want to do is amend your budget to include this $5,000 that you now need for the roof repair, and assess that to the unit owners. Now, in an ideal world, the supplemental assessment would be over, say, 6 months. But 6 months, 6 months is better than 3 months. 3 months is better than 1 month. But the fact that you're amending the budget and calling it a supplemental assessment is infinitely better than calling it a special assessment, because you're dead on arrival with those words. So, a one-time supplemental assessment, it sort of looks and smells like a special assessment. So that's a bit precarious. But over 3 months, over 6 months, and over 12 months, now you're really talking. Now it's really just a second condo fee. And we're going to be able to get that paid for you in almost every instance. Not a guarantee, but we're very, very successful in getting supplemental fees paid. You'll see them not only for sort of unexpected events like a tree, but if an association gets a loan that's paid over, say, 5 years, they're going to call that, loan monthly fee, condo fee 2, something like that. And that's just going to be part of the priority lien. That will be no problem. Oops. And anything more to say on the non-priority amount, Will?
No, I just in terms of what you were saying about the special assessment. I mean, ideally the best way is just if you can just increase the condo fee that month, and so it's not even distinguishable. But I understand that can be challenging, and the smaller the amount, the more it can be spread out, the better. It's a kind of simple rule.
So as far as Will talked about the priority lien. Why is it 6 months? Well, it's because that's what the statute says. And if we file suit in October, the look back is 6 months from then. So May, June, July, August, September, and October. There's your 6 months right there. And as I just discussed, the special assessment, fines, late fees, just not part of the priority lien. Now, years ago, there was a case, Drummer Boy v. Britton, where the Britons were unit owners in a condo, and they challenged the ability of their condo to have multiple priority liens in place at a single time. And the condo won, then the Britons won on appeal, and then finally the condo won before the SJC, the Supreme Judicial Court of Massachusetts. That's our state Supreme Court, if you will. So now the law is that at any given time, a condominium can have multiple 6-month priority liens. So, when you're in court, you filed suit, there's necessarily about 6 months owed. By the time you get a judgment, it's probably more like 9 or 10, sometimes 11, depending on how slow courts are. So now you've got this sort of fresh 5-month period following your priority period. So this case is black letter law, as we like to say, that now you can send new statutory notices to the owner and to the lender, advising them that there's a new delinquency, and then file a second lawsuit to get a second 6-month priority lien. I'm sorry for the coughing, everybody. It's brutal. So, you can have 12 months, 18 months priority at one time, so long as you follow the process. But I have never done a third one. I mean, to me, it's unheard of. You'd have to be an extraordinary set of circumstances to require a third case being filed, because you should have either foreclosed on your first case or someone should have paid you by the time you need a third one.
And there are, just on that point, there are cases that can get ugly, and most of the time it's because of a deceased owner or some sort of title issue that comes up that can kind of drag things out that might lend itself to getting into that 3 complaint range. But I think one of the takeaways from that is just kind of really keeping it basic, that if everything is done and it's sent over to us on time, we can collect every single month of condo fees. That if we're on top of it and we're doing what the statute and law allows us to do, the association will not lose a month of condo fees. So that's a great thing.
Will, you want to take this one?
Sure. So impact of lender foreclosure sale. So first off, I'm just going to give kind of anytime an association receives a notice of foreclosure sale, it's a huge flag. And you should instantly look at the unit and see if there's any sort of delinquency on there, whether it's 1 month, whether it's 4 months, whatever it is. And if there's a balance on that unit, then you should reach out to the attorney to look into it. Because if the bank forecloses and there isn't a lien in place, and that means a complaint on record, then the association's lien is wiped out. We potentially can't get it. There's some ways we can try, but it technically, from a legal perspective, it's technically wiped out by the sale. So, just as a note from this, anytime you see a foreclosure notice, reach out to us so we can assess whether any action needs to be taken prior to the foreclosure sale. When the foreclosure sale happens, again, if there's any sort of lien on the unit, we're gonna put a lien in place prior to the foreclosure sale. Once the sale happens, who is responsible for post foreclosure common expenses? Now, here we're talking about the lender foreclosure sale. And part of this is we don't really care because somebody's going to be responsible. Whoever there's going to be a lien on the unit from the date of that foreclosure sale forward. Now, technically, it's who the record owner of the property is. A lot of times banks will foreclose and they won't, and the bank will buy it back at the foreclosure sale because they didn't get enough money, and it'll take months before they end up selling it on their own. And the old owner will still be the record owner of the unit, even though we know the bank foreclosed and is eventually going to switch title. But for our purposes, we would still go after that prior owner because they're still the record owner. Once a new record owner goes on, whether it's the bank or a third party, they're the ones that we would then go seek to enforce the lien. But the lien itself, again, it's automatic. And from the day of that foreclosure sale forward, that whoever's the owner is responsible for it. Will the association get paid? Yes, the association will get paid if, again, once we put that lien in place and we prioritize, we will be able to collect the priority lien amount, right? Remember those condo fees and the attorney's fees and costs, those will definitely that happen before the sale. Anything after the sale. So condo fees, late fees, fines, specialists, anything after the sale we'll be able to collect. You might have to be patient sometimes, but again, we're still kind of in that 6-month track. If we filed suit right before the sale, we'd be filing another suit 6 months later if we hadn't gotten paid and hadn't gotten some sort of resolution on it. Who is responsible to maintain and upkeep the unit? So again, technically the record owner is. I have had cases, especially with winter coming up, where we know the unit's been foreclosed on, we know it's abandoned, and we know the bank bought it back at the foreclosure sale. We'll reach out to the bank and say, look, you need to get your property preservation team in there to make sure this is winterized because it's vacant and it needs to be taken care of. So, Dean, anything else on that?
About maintaining, sometimes the owner's gone, but the bank hasn't foreclosed yet, and it's, the middle of December, middle of February. And if you winterize that unit, or if you start paying for heat, you're probably not going to get that repaid by the bank because that's not part of the priority lien. But my advice is almost always just do it. Would you rather pay $50 a month providing heat to this unit, or having to deal with a $30,000 insurance claim because a pipe bursts and affects the unit below, common area, etc. But post foreclosure, as Will mentioned, you're going to get everything. So if you have to do a special assessment or anything else, if there are fines for failure to maintain the unit, it's all going to get paid by the lender when they finally get their foreclosure deed. on record, which can take a ridiculous amount of time, because bank attorneys are slow and condo attorneys are fast. In my
And
view,
there are some arguments to be made to collect those. Like, all is not lost, even if they technically don't have to pay it.
true.
We've got some pretty good relationships with bank counsel, and we make some pretty good equitable arguments that, why should the bank get this benefit and the association pays it? Whether those would hold up in court if really pushed, not certain. But again, it does, especially if the amount isn't too significant. We've got some pretty good success in trying to get those amounts. So do it. Don't give up on it.
That's right, because at the end of the day, you're protecting the bank's asset. The asset secures their loan. So if you're winterizing it for them, preventing it from having a catastrophic burst pipe situation, the bank has benefited as well as the association. So once in a while, owners who are in collections will file for bankruptcy, and that changes everything. But all is not lost. Sometimes owner or boards see that a owner has filed for bankruptcy and they figure that's it. We're never going to see a dime of this money owed. Not true at all. It complicates things for sure, and it slows things down for sure, but all is not lost. So let me just take you all through some bankruptcy lingo, and we'll get into the nuts and bolts. So often you'll see a Chapter 7, which in my view used to be a lot more common, especially in the 08, 09, 2010 range. This is a straight liquidation where you're basically giving up. If you have a condo, you're saying, bank, take it. You have no money, you have no ability to pay anything back. You're basically getting a fresh start through the bankruptcy process. Chapter 13 is by far what we're seeing more of over the last 4 to 5 years at least. And this is the reorganization. So if you have credit card debt, if you have unpaid medical bills, things like that, those are going to get wiped out by your bankruptcy. But any secured debt, like your mortgage, like condo fees, are going to get repaid through the Chapter 13 plan. And typically, it's either 3 to 5 years, but almost always it's 5 years. So if an owner owes, create a number, $5,000 as of the time he files for bankruptcy, that $5,000 gets put into the plan, in addition to the mortgage debt and any other secured debt. And you take that $5,000 and you pay that basically over 60 months. It's not exactly equal installments, but it works out to be about that. So, this is tough on boards. They want that $5,000 yesterday, but now they have to wait 5 years to get it, assuming the owner stays in bankruptcy. So how this plays out is, as soon as you file, you create a plan or you propose a plan, and that plan has certain payments, and you immediately on a monthly basis start paying money to the Chapter 13 trustee. This is a lawyer who all they do is manage people's Chapter 13 plans, so they couldn't be more of an expert, and they're in charge of making sure the owner every month pays the right amount. And as the bankruptcy trustee gets money, then they start cutting checks to everyone who's entitled to one. Usually it's going to be a town for taxes, the mortgage company for the mortgage, and the board for the condo debt. And then as long as they're paying each month, the debt gets paid over time. But and simultaneously, they're required to pay the monthly fee on an ongoing basis. So if you file for bankruptcy today, whether it's a 7 or a 13, you're supposed to pay the monthly fee starting in November. If you filed a 7, they're simply not going to be paying you. So it just doesn't happen. But in a 13, they must. And if the owner fails, either in a 7 or a 13, to pay monthly on what we call a post-petition basis, the petition being the bankruptcy case, then you go into court and try to get permission to start collecting again. But we'll get to that in just a second. Chapter 11, usually for businesses, so I'm going to just skip right past that. The automatic stay is what happens when you file for bankruptcy, and it basically stops any creditor from pursuing a debt. So we might have a foreclosure sale scheduled for tomorrow. We might have a hearing scheduled for tomorrow. Once they file for bankruptcy, that collection case, lien enforcement case, is put on hold. You simply cannot proceed with any collection activity due to the automatic stay. But as I mentioned before, well, we'll get there on the next slide. So pre-petition, as I mentioned, that's the amount owed as of the date of filing. And in a chapter 13, it's what gets paid through the plan. Now, so the way the court finds out about what's owed as a condo debt is two ways. The owner is supposed to set that forth in their proposed plan, but they usually don't know the exact amount. So what I do for our clients is file a proof of claim. And all that is a statement of what's owed: the condo fees, the late fees, the legal fees, anything that's owed goes in the proof of claim, and that's what gets paid. Now, when the owner doesn't pay on a post-petition basis, now again, that's the ongoing monthly fees, we file a motion with the court called the motion for relief from stay. And what that means is you want the ability for the stay to be lifted as to the condo, because the failure to pay monthly, and this goes for banks as well, is very prejudicial to the creditor. The creditor needs that money coming in, and if they don't, they're entitled to sort of re-pursue the debt again. So once the automatic stay is lifted, it's as though the bankruptcy case is gone, and you can go after the debt once again. And a discharge is what you get when you complete a bankruptcy. So in a Chapter 7, you basically eradicate all debts, and if a debt is secured, you allow the creditor to pursue the secured debt, usually through foreclosure sale. But the owner loses their personal liability for the debt. So even in a Chapter 13, if you've reached the end, well, you've paid it off. But in a Chapter 7, you can never go back to that owner and say, well, you failed to pay X amount of dollars. They lose that personal obligation, but the lien, that doesn't go away. And that's why I say all is not lost when someone files for bankruptcy, because you have that security of the lien. You have the automatic lien and the priority lien. So what happens when someone files for bankruptcy? Stop, drop, and roll. You want to stop all communication with the debtor, and that includes just sending some clients will send monthly statements to owners. You have to stop that because it can be construed as an attempt to collect the debt. And like I said, the automatic stay means all debt collection activity must stop. So you don't want to send the owner, anything. Leave it up to your attorney to handle all communication. Drop is, again, the automatic stay means everything's on hold. So you're dropping collection efforts. And roll, this was sort of a stretch to come up with roll, but roll meaning notify your attorney right away. Sometimes the notice comes to us, if there's an active collection case, but if there's not, it's probably going to go to management or the board. So notify us as soon as possible, because if you don't file a proof of claim within 90 days, you can't get that paid. So highly important to keep communication open with your attorney.
Hey, Dean, before we go down these practical tips, I'm sorry, was there any more on the foreclosure? I just, some good questions have come in. I thought I'd take
Yeah,
them.
let's do it. Absolutely.
So there's a few good questions that came in. I might summarize them just to keep them simple here. But the first one is regarding a kind of an 8-unit residential commercial condo, but there's only 2 owners. And the question is basically, one of the owners sounds like they're not paying their condo fees on a regular basis, but they are performing work and stuff around the condo, and it's spending money on that. And obviously we don't know the amounts and things like that. So, and then there's another question as far as, this is kind of an informal condominium. It's not really operating, formally, so do they have to pay the condo fee? So again, there's a lot here in this question, and I'm just going to take two quick things that jumped out at me, and there might be a lot more facts to it, and my answer might change if I knew everything. But regarding that initial question of one owner is not paying, but they're doing work around the condo, that's called offsetting, and offsetting is impermissible. And I know what happens a lot of times, especially in small condos, where one person fixes this and another person fixes that. But pursuant to the condominium documents and statute, the association should have a budget, and the owners have to pay based on their percentage interest in the condominium, no matter what. If they spend X number of dollars over here to fix the driveway, they can't not pay their condo fee. Technically, they need to pay their condo fee, and then they could seek reimbursement for the association for the money they spend. The other thing regarding, again, I know this happens a lot in small condos, they kind of skirt the rules. If you skirt the rules, you do so, at your own peril. A lot of times you get away with it because it's small and everybody knows each other, but at some point it could be a big issue, and it could be challenged. So again, not knowing all the facts here, my recommendation is just make sure look at your condominium documents, and make sure you're complying with them, as much as possible at all times. Otherwise, you're opening yourself up to some potential issues down the road.
Yeah, in the 8-unit condo with 2 owners, I would want to know, how do you become a trustee? Because there should be multiple trustees. So I'm gathering that these 2 individuals own more than 1 unit. So I presume they can appoint different trustees. So I think it's going to be up to the board, and maybe you need to constitute a board to start a collection case against the owner who's failing to pay. 2-unit condos, I know this is not a 2-unit condo, but it presents the same problem as a 2-unit condo, where most sets of docs don't allow one owner to go after the other, and it's very difficult to collect fees in that instance, although there are options for sure. There was even a case in the last year or so where the judge said that the condo docs required a unanimous vote of the 2 unit owners to make a decision, but one owner just didn't want to do anything, wouldn't show up to meetings, wouldn't communicate, and the court found that that owner basically disqualified themselves, and the remaining owner, who was trying to do the right thing, who was trying to pay bills, could bring a collection action against that other owner. I think that was a Superior Court case, so it's not binding across the state, but it's a great precedent for our clients. But for the person in the 8-unit, get a board appointed and bring a collection case.
Couple more quick questions, Dean. There was another one. This is kind of reiterating that special assessment versus supplemental fee issue. This question was related to a major fire loss, and is about to impose a $20,000 assessment. Again, what the cause of the assessment doesn't, I guess, matter as much as how it's budgeted and how it's assessed to the owners. To the extent that assessment can be spread out over time, and either in an additional condo fee or a increased condo fee, the better. I understand that sometimes that can't happen. Sometimes it has to be done in a month or 2 months or 3 months. If that is what it is, then so be it. And you just want to still budget it as a supplemental fee or an increased condo fee. And again, it would be somewhat of like an amendment to the budget. Basically, there was this unforeseen cost, so you had to amend the budget to then add this additional fee. Oh, here's a good question. Can an association bid on the lien foreclosure sale? Are there limits to the bid? Must association get appraisal and bid only up to the lower of the appraisal or the lien? Typically the only reason why an association, I shouldn't say, what I've seen in my experience is an association contemplates purchasing the unit at a foreclosure sale because they don't think there's going to be enough, there's maybe no mortgage, and they don't think it's going to get bid up high enough to cover what's owed to the association. So it's a pretty rare case that would happen. But you could imagine a case where there might be a large supplemental fee or a special assessment or something, that a lot is owed and they don't think it'll sell for that amount. The association has every right to bid on the property. This is a public auction. They're going to have the same, notice that they do have a little inside information because they know exactly what's owed on the unit, and that's going to, help shape how much they bid. But everybody's free at the sale to bid. As long as the process is done correctly, then the association does have the right to bid. Dean, any more on that question?
No, I totally agree. And even individual trustees can bid as long as they're disclosing that to the other trustees. Like Will said, it's a public auction. Just because you're a trustee doesn't really give you like a strategic advantage in terms of your ability to outbid anyone else. It's all in the open. So if I'm a trustee and I want to bid for myself, for Dean Lennon, the unit owner who happens to be a trustee, I would just let the other trustees know that I'm doing that. The hardest part, for a condo trying to acquire the unit might be acquiring a loan to finance it. But perhaps you could just, if there's just no interest from other bidders, you could essentially bid what's owed, so no money is needed. So you sort of wipe out the debt and you have this receivable hanging out there. And then when you resell the unit in the future, then you're sort of paying yourself back through what's acquired. So let's say, $30,000 is owed. No one shows up to bid for whatever reason. Now the condo acquires it for $30,000. So you kind of wipe the slate clean for unit C. Then a year later, you sell unit C for $50,000. That $50,000 goes right into your operating account. So you've repaid yourself 30 that was never paid by the former owner, plus the 20K of profit.
A couple quick bankruptcy questions for you, Dean. Is the condo lien considered secured in the bankruptcy claim filing?
Yeah, it's secured even if you don't have a priority lien, because the 183A section 6C gives an automatic lien. You're automatically secured.
Okay. And other quick question: can you continue to send monthly bill if owner files for bankruptcy?
No, definitely not. You don't want to do that. Even if it's just to say, hey, November is owed. I mean, I guess you could send that if you really felt the need to, like some sort of monthly invoice, but you don't want to have that prior balance on there because, again, it could be construed as an attempt to collect the debt. And it's a violation of the automatic stay. So we want to wear a white hat. We don't want to overstep our legal bounds. We want to do the right thing. So it's best just to shut it off completely.
Okay. We got a few more questions, but why don't we maybe get through the rest of our material there, and then we can circle back and, if we have enough time. All right. So practical tips. Again, we keep kind of going back on this. Start the process earlier. I know, some associations, it's automatic. They have a system in place, and they'll send out notices and they'll send it to us. But I really can't emphasize enough that the sooner an owner is made aware that they're behind, and it gives them more opportunity to cure it. And at the end of the day, actually saves them a lot of money. A lot of times, if an association waits too long and it comes to us near kind of the deadlines, we have to move really fast, and then there's a lot of legal fees that get tacked on. And even though the intent might be to help a unit owner by not sending them, at the end of the day, it actually hurts them because they get a lot more legal fees and costs incurred a lot quicker than they would have. Budgeting for shortfalls, certainly, obviously, just good practice. We can't always predict. You have your budgets that are, you can calculate from year to year what you can count on, but the association should also budget for those shortfalls so that if there are a big assessment, it can cover it. And that way you're avoiding kind of that one-time big special or supplemental assessment or fee, that's going to really sink somebody. But if you can budget ahead of time and they pay it off over time, they're less likely to get in trouble. All right, we talked about the no special assessments quite a bit. I don't think we need to go over that one again, but consider repayment plans. This especially, back in 2008, half the people who weren't paying their condo fees weren't even living there. They never paid a condo fee. They were in way over their head. They just walked away. It was a totally different animal during COVID, where people, were out of work and things like that. And it's just boards, associations, you can be compassionate and try to work through and try to work out plans with folks as long as they're reasonable. And it always helps us going into court when we can say to the judge that, look, this wasn't a quick rush to judgment here, that the board tried to work with them over a period of time. That always, I find, carries a lot of weight. I don't know if Dean's had different experiences there.
Yeah, again, we're wearing the white hat. It does look good that you didn't rush into court. You tried. Really, anytime a plan, as long as the owner doesn't get past 5 or 6 months owed, you have nothing to lose by trying a plan. If you put the owner on a plan and they get 9 months in arrears, well, that's really dumb. That makes no sense. But as long as the owner sort of tread water, pay down over time, you're no worse for the wear. You can still get that priority lien established the moment they miss a payment altogether. So, again, just keep that owner in the, 0 to 4 month range. And if they get to 5 months, that's when it has to come to us. You just can't wait any longer, because we want to send those statutory notices no later than the 5th month, and then file suit in month number 6. So latest trends, property values rising, which is a good thing in the sense that, unlike 08, 09, where values were going down and people were underwater, people can just sell their units and they can pay back everybody and still walk away with money. And perhaps lenders are more willing to just outlay the funds sooner than later because there's the equity cushion in the unit. Less foreclosure sales, this is true for the last 5 years at least. There's just very few lender foreclosure sales these days. We all thought we'd see a spike in collections in 2020 when COVID shut everything down. Really hasn't come to pass. Maybe a modest uptick this year, maybe, but nothing like the Great Recession. Banks have sort of become accustomed to paying, and they're paying when they get lien notices. Sometimes they don't even contact us; they just get the letter from us and send us a check. We would like to think we train them over the years. Just they know the routine at this point. They know our firm, and they see our letters. They know we're doing things the right way, and they issue checks, and we can send them off to the client. And I love sending checks to clients. It's the best. Fewer abandoned units. It's just not like the Great Recession, where people just literally said, well, I'm 50K underwater. I'm not going to pay anybody. Why would I? I'm gone, and I'm going back to wherever. But what we are seeing an uptick in is deceased owners. And I have no theory on this, but it seems to be coming up all the time, where you have no lender, no liens, but the owner's gone, and seemingly they have no children either. So you're in a situation where there's no one who's going to pay you until you foreclose. Well, you want to talk about that a little bit?
Yeah, I think just from a practical perspective, it doesn't impact the lien. It doesn't impact our ability to collect it. Depending on the circumstances behind the situation, it might, there has you have to be compassionate. Sometimes the person has been deceased for a long period of time. Other times, it's fairly recent. So obviously you kind of have to take a little more on a case by case basis. But still, with those guiding principles, that you still got those 6 months to work in, and you can be compassionate and understanding, but you also need to protect the association. So I think boards and managers need to understand those cases can take a little bit longer. There are certain probate issues. A lot of times we'll get requests to hold off, or just trying to establish the have somebody appointed as representative of the estate. it's going to get paid. And again, doesn't mean we don't have, you still want to file that suit because you want to get that lien in place just in case. But, you know, it can take a little bit longer, but the association is still going to get the money. Just have to be a little more patient on it.
So limitations of the condo lien. Judges and the first two, judges and counterclaims, sort of go hand in hand. Most judges understand the condo statute and they understand the case law. You know, the both are very, very, very tilted in favor of our clients. The fact is, owners don't have the ability to offset or deduct condo fees, even if they have legitimate claims against the condo. You know, maybe they're waiting on a check for an insurance loss. So once they get that check, then they're going to pay their condo fees. Well, the law says they have to pay them. Maybe there's a claim against the board because the board didn't maintain the roof and the unit was damaged and they had to shell out cash to repair it. Again, they have to pay the condo fees. They can't offset by a counterclaim, but some judges just don't get it. They haven't seen cases like this before. They're not trying hard enough to educate themselves, and sometimes cases go the wrong way due to bad decisions, but they're very, very rare. But, you know, we're just highlighting the fact that this is not a panacea. The priority lien is incredibly powerful and the case law is powerful. Sometimes things go awry. Sometimes owners file counterclaims and those should be dismissed because, again, no right of offset or deduction or waiver. So when owners bring counterclaims saying the board hates them, the board doesn't maintain common area, the board doesn't do this or that, though that has no bearing on the ability or the requirement, the legal obligation to pay monthly fees. So typically we can get those dismissed, but at times judges, they don't care to educate themselves. I had a case recently where the owner filed the counterclaims. He said that we didn't, I say we, I'm not on the board, but our clients, we're all on the same team. So I say we. So they said we didn't maintain the roof and he was damaged. And I tried to dismiss those counterclaims. The judge said no. Then I filed a motion for summary judgment saying X amount of dollars is owed. He has no excuse not to pay. The judge could not have cared less about the counterclaims. You could tell he wasn't listening during the hearing. And that was denied. So I had to go all the way to trial, which I think I've had 2 over 13 years, unbelievably rare. But we had a trial and we won. And this owner, who could have paid $1,000, ended up paying over $20,000. 1, because he just refused to pay, but 2, because we had a terrible judge who didn't know the law. But at the end of the day, we had a different judge for the trial, which was nice. We prevailed because the law is what it is, and this owner should have paid. So thankfully, it took a really long time, and the board was not happy to wait as long as they did. It was probably, I don't know, 18 months until they got paid, but they got paid in full, and the owner paid a dear price there. And then, of course, non-priority charges, as we've dwelled on many times. We're not going to get those paid. Usually, sometimes banks cut checks. They just cut a check for whatever the bottom line is, but they don't have to. So that is a limitation on the priority lien.
Yeah, kind of tying into that, you know, all these things that are considered non-priority, they should always stay on the ledger. Never take them off. Even if the bank pays the priority lien, everything stays on there. If the bank forecloses, leave it on there. At some point, the bank is going to, you know, say, look, you know, there's a new owner in there and they want a clean 6D certificate, which I'll talk about in a second. And at that point, things may come to a head and you might have to make a decision whether to put it off. But there's nobody's, you know, the bank telling you to remove something from the ledger doesn't obligate you to do it. All right. A court order would obligate you to have to take it off there. And, you know, there's other things, but a lot of times, you know, I've seen foreclosure sales that they've done it and then they've had to redo it for various reasons. So if you took that lien off the unit and then the bank and the foreclosure sale was no good, you would have taken the lien off for no reason. So always keep it on there, and and talk with an attorney about when it's time to take a non-priority amount off. But don't just do it because the bank said you had to. There's more to it than that. Now, regarding the 6D certificate, this is kind of this is a certificate that the association gives out, when it's requested. The association has a certain period of time to give the 6D certificate. And basically it says, if somebody records a 6D certificate, it's a clean 6D certificate. It says that there's nothing owed, there's no liens on that unit through the date of the foreclosure, or excuse me, through the date of the 6D certificate. Now, a couple just key points I want you to take away on that. One, there's two types of 6D certificates. There's the clean 6D certificates, which says there's nothing outstanding through the date of the 6D certificate. And then there's a dirty 6D certificate. A dirty would be if there's $2,000 or an amount of money that's owed, you would put that on the 6D certificate and say, as of October 18th, there's $2,000 outstanding. And then the association is represented that amount is owed. If there's money owed on October 18th, if there's $2,000 owed and the association gives a clean 6D certificate, the liens that says there's nothing owed, it's gone. So you really want to be careful when it comes to issuing 6D certificates. If there's if the matter was with counsel, you want to make sure all the attorney's fees are accounted for. You want to make sure there's nothing else that's out there, because once you issue that clean 6D certificate, you're really losing your right to enforce the lien for that amount, absent going into court and showing something. The other thing I would say to be careful about is the date you put on the 6D certificate. You should never put a date to the end of the month. Banks, realtors always ask this. They want us, they ask for a 6D on the, October 3rd, and they want it clean. They want a clean 6D through the end of the month. Never do that, because even though you might not think there's going to be an assessment, it's always possible that something could happen that would get assessed in between October 3rd and the end of the month. And if you gave that clean 6D to the end of the month, you're potentially out of luck. The last thing, and this one's kind of tricky, and it's something that, again, I would recommend you talk to an attorney before you do it. But a lot of times there's an assessment that's coming up, right? You know that next month there's, it's budgeted, but it's not due until, it's budgeted in September, but it's not due until December. And a lot of times a board might, or an association might think that, okay, there's nothing due through today, so I'm going to give this clean 6D certificate, and they don't acknowledge that there's this budget assessment that's going to come due later on. Potentially that owner could the new owner could make an argument that they don't have to pay that a supplemental assessment or whatever it is, because they weren't told about it on their 6D certificate. So if there's an assessment coming due, even if it's not due when the 6D is requested, there's a good chance you're going to still want to reference it on the 6D certificate. So again, if you have any questions on that, it's really important that you check with an attorney, because you could potentially lose it. All right, it looks like we're 11:10. We're a little bit over. There's quite a few questions that have come in. We've handled some of them. We'll do a few more. But if we don't get to your question, I'm going to try to just pick some quick ones that they're not too wordy. But if we don't get to your questions, feel free to email Dean or myself, and we're happy to get back to you at another time.
The first slide has both our emails, and we'll get back to you.
Okay. Okay. Oh, here's one for you, Dean. What can you do about sporadic payments? Can you get to an accumulative amount for a lien notice?
Not sure I understand the question.
I'm reading that as your owner pays January, doesn't pay February, doesn't pay March, then pays April, skips May.
Okay. So what I think when someone's paying intermittently, you always want to apply it to the oldest amounts owed. So at the end of the day, you want the arrearage to be constituted or comprised of the most recent months of fees. So if the owner owes, just say $900 and your condo fee is $300 a month, you want to call that August, September, and October, even though they made a payment in October. You're taking that October payment and you're applying it to, say, the July fee or the June fee, whatever the case may be. And you're always keeping that arrearage current, if you will. The arrearage, you want it to be recent fees. And sometimes another sort of higher level trick, let's say you do have a special assessment because you hadn't attended our seminar and you didn't know. So you want to take those owners' payments, and if the owner doesn't write October fee on it, take that payment and apply it to the special assessment until it's paid in full. And that way you're sort of creating a priority lien if need be. So instead of owing the special assessment, all of a sudden the owner owes 4 monthly fees instead. Hopefully that makes sense.
Here's another one. I'll take this one, Dean, since I just talked about the 6D certificates. If you have a 5-year special assessment payable monthly for 5 years, do you need to put the full balance of the assessment on the 6D certificate? So I would say I would put it on the 6D certificate exactly how it needs to be paid out. So if it's a 5-year assessment, there's a line you can put right on the 6D that says, there's been an assessment in the amount of X, and then you could even put there, payable monthly over the next 5 years, and just put it right on that 6D certificate. And typicly what happens with that is, look, then the seller and the buyer will negotiate that into their price. Where you get into disputes, and the condo association doesn't want to get into these disputes, is when that's not on there. Then the seller got the benefit and the buyer's now ticked off that they have to pay it and they didn't know about it. So if everybody's aware of it, they can figure it out on their own. So that's what you want to do in those situations. Why don't we take one more? And this one kind of goes to the counterclaim one you were just talking about, Dean. So in case you discuss with counterclaims, what if an owner says breach of fiduciary duty to maintain habitability of unit due to not fixing roof? I understand condo fees must be paid, but would not the counterclaim also offset the partial judgment on the assessment?
Yeah, in theory, it would, but the Section 7 of the condo statute is explicit about no offset. So you have to pay in full and then bring your counterclaims in a separate action. So your counterclaims are just claims in your own action. So yeah, I mean, if the law didn't exist, that would make sense. They owe 1,000, but you owe them 500, have them pay you 500. But it's simply not what the law states, and it's for good reason, because owners would always be trying to say they're owed something or withholding payment until they get their money first. So they might have their breach of fiduciary duty claims, and it might even be viable, but they're going to have to pay you in full and then litigate their claims. And then maybe they get all their money back because they're successful in that lawsuit. Hopefully not. Hopefully their claims are baseless. But no, the answer is no, they must pay you first.
Yeah, and I would add to that, the case law on this is that a unit owner must pay timely monthly assessments. So, the whole idea was condo fees are the bloodlines for associations. It's what they need to operate. And, as Dean just pointed out, if a unit owner was ticked because they think there was an issue with the roof and they didn't think they should have to pay the condo fee, that interrupts the bloodline. It interrupts the flow of money coming into the association. So the courts and the statutes say they're separate. They're not, you can't put them on the same page. You got to deal with one and then deal with the other. I can't help it. One last question. All right. This is fun. I like having all these little. All right. This is can you require a special assessment to be paid in full at the time of sale and put that on the 6D? I get this question a lot. A lot of boards, there'll be a special assessment similar to the question we just had a minute ago, where it's going to be over 5 years. And the association will be like, well, we want it paid right now at the time of a closing. We want to get this one paid up front. And, typically I say, why does it matter? If the unit owner continued to live there and they could pay it out over 5 years, why not just let them pay it out over 5 years? A lot of times the boards will, when they assess that special assessment, they'll put language in there that says if you move, it accelerates and you have to pay it at the time. So can it be done? Yes. It's helpful when it's clearly stated that it has to be paid at that time. A lot of times though, I don't know if it really matters, but there may be a case where a board feels like it should be done that way. But to me, I mean, I would think from a management perspective, a lot of times these things are like tied in with interest and amortizations schedules and things like that really kind of make things more complicated. So simple answer, it can be done, but is it always worth it? That's another question. All right. We're at 11:16. Again, there's a bunch of questions we didn't get to. Some are a little wordy, lengthy ones. Those ones, again, feel free to shoot myself or Dean an email and we'll get back to you. But other than that, thank everyone for joining us this morning. I hope this was helpful. And again, happy to answer any additional questions you have down the road.
Thank you very much for coming, everybody.
Thank you. Thanks, Dean. Good
Thanks.
job.
Good job.